Okay. Oh, this is on page 52. 52. All right. So now we're going to talk about what we call tort law. This will take us into next week. So remember back to the beginning of the term, sort the different categories of law. There's civil and criminal. And then there's civil. We have a whole bunch of classifications. Contract law, real estate, family law, probate. And one of those classifications was tort law, including negligence and other types of torts. So we're talking about civil. This is civil. So first of all, the word tort is a French word that refers to a wrongful act. Right here, wrongful act. A civil wrongful act. So this is essentially somebody does something wrong, injures somebody, damages their property, their reputation, they publish something false about somebody, they steal something from them, they do something wrong where somebody else is harmed, either physically or monetarily or whatever, right? A wrongful act. And tort law is the area of civil law, then, that allows the person that's harmed, the victim, if you will, to file a civil lawsuit against the person that caused their harm as a tort. Tort law is kind of like criminal or civil criminal law. Now, let me explain that a little bit more. Criminal law, how do we tell it's a crime? Criminal law, remember?
Jail time.
Possibility of jail time. If there's a possibility of jail time, it's a criminal law. Civil law, no jail time. So this is one of those areas where we have an intersection between criminal and civil, like I talked about a few minutes ago with burden of proof. Now here's what I mean. Most of the torts that we're going to talk about, especially intentional torts, are usually also a crime. So like if I walk up to somebody and I punch them right in the face on purpose and I break their nose, that's a crime. That would be assault, criminal assault. That's also going to be an intentional tort. So I could be charged in criminal court for punching somebody and convicted of the crime, and then that person could also sue me in civil court for the very same action, to be compensated for their medical bills, if they have permanent impairment, and their pain and suffering. So the reason I'm kind of harping on this is we're going to be talking about a number of different intentional torts, and you're going to say, well, wait a minute, you can't do that, that's a crime. Yeah, it is. It's a crime, but it's also a tort. So they intersect with each other, all right? Now, I will also tell you that some of these go by different names, depending on what state you're in, and even what city sometimes, federal or state. They have different names for the same thing. So in one place it might be called a battery, in another place it might be called an assault, or it might be called an assault and battery, or it might be called physical impairment, or unlawful physical injury. They go by different names, but they all have basically the same idea. All right, so tort law, the point I'm making, is civil. Criminal law and tort law overlap each other. Again, a person may commit a crime. The victim can also then sue them in civil court. Question? No, stretching. Okay. Yeah, question?
What example of overlapping?
Okay, so let's say I punch somebody in the face, right? That's a crime. It's also a tort. It's also this. It's a violation of two types of law. So it's both a crime and a civil, right? Because they're different courts. You have criminal court, and you have civil court. So they're two different categories. So that goes back to like classifications of law. So let's talk about that some more. Go to the next page, okay? Page 52. Somebody else had a question? Any question?
Just a quick question, like, does that also fall back to where the criminal court is at a higher standard of proving?
The honors of the preponderance of the evidence. Okay. So this, what this chart, or this page is talking about, is what I've been going over here. So a person may do something wrong, and that wrongful act, what I did wrong, can be a violation of criminal law, and contract law, and tort law. All three areas of law. So for example, you guys ever heard of Bernie Madoff? Bernie Madoff. You know who Bernie Madoff is? Great name for a crook, right? He made off with a whole bunch of money. So Bernie Madoff was a guy back on the East Coast who was a financial advisor. And basically, he would invest people's money, or so he said. In reality, what he would do is he would go get money from one person, give me your money, and I'm going to guarantee you a 10% return. I'm like, okay, I'll take that. And then I take your money, and I go find somebody else, and I say, invest your money with me, I'll give you a 10% return. So you give me your money, and I take part of what you gave me, and I give you 10% of it back.
Ooh,
Right?
I like that.
And then I go to you, and you say, hey, give me your money, so I do that, and I give her some of your money. And I keep on going, right? Now, I'm not really investing this money, I'm moving it around from one person to the next. I'm not really making 10%. It's called a Ponzi scheme. Now, eventually, I run out of people. And so now I don't have the money to pay you, or
Yeah.
you, and the whole thing just crumbles. That's fraud, it's theft, it's a whole bunch of misrepresentation, it's conversion.
So what was the purpose of the whole thing?
I'm stealing money from you because I'm pocketing all that money. I'm giving everybody 10%, and I'm pocketing the rest of it.
Gotcha.
That's crime. He's in jail now for that. That's also a breach of contract because you hired me to manage your money. That's also the tort of the least conversion, fraud, deceit. There's a whole bunch of it. So one act, taking your money, violates all three areas of law. Does that make sense? So the criminal part of that would be prosecuted by the government. Only a government can prosecute a crime. The proof would be beyond a reasonable doubt. In civil law, contract law, tort law, proof be to a preponderance of the evidence, P of E, that's what I have here. And the victim would actually file their own individual lawsuit in that case. That's what most of his victims have done. Yeah.
I guess that's another question is, at that point, if they've already been convicted in the criminal court, and you file your civil case, I mean, do they actually have to go through the whole process again, or they just?
Okay, well, typically speaking, you're found guilty here. You can then file for what's called a motion for summary judgment, basically automatically win down here, yeah. And then it's just a matter of damages, how much. Yeah, because fault is basically established at a higher level here, and then damages will be determined. Yeah. All right, let's move on. Oh, back to my categories. So, page 52 again. All right, so under tort law, we have three broad categories I want you to be aware of. First, we have what we call intentional torts. Intentional torts. Now, this is basically the idea that somebody does something on purpose. Not accidental, not oops, but I'm doing it on purpose. Intentionally. I'm thinking, this is what I want to do. I want to hurt you. I want to damage your property, your reputation, or whatever. I'm doing something intentionally with the idea that you're going to be injured, or maybe not so much that you're going to be injured, but I'm doing the action that leads to your injury on purpose. So it requires proof that the person committed the act that led to the harm intentionally, not accidentally. And I'll give you more examples of that in a minute. Those are considered worse. The next layer down is an action that causes injury physically, property damage or whatever, some kind of harm, physical or monetary, but it's done unintentionally. This is oops. Sorry, didn't mean to. Doesn't matter, you still pay. Why? Because you were negligent. Negligent is what I call an unintentional tort. It doesn't matter if you didn't mean to do it, you're still responsible. Classic example of negligence: I'm not paying attention, I'm fiddling with my radio while I'm driving, and I don't see you in the crosswalk. Ran you over. Oops, my bad. Didn't mean to run you over.
But you get anyway.
Yeah, but I pay anyway, because I was negligent. I violated my duty to look out for a pedestrian in the crosswalk. Now, if I did it on purpose, I see you, I speed up and run you over, that's now going to be called a battery. It's also a crime. So, intentional tort requires intent. Negligence, unintentional. And finally, we have what we call strict liability, which we won't get to tonight, that'll be next week. Strict liability is essentially when you pay no matter what, even if you're not at fault. Or in other words, we call it no fault. Tort law. Classic example of that would be workers' compensation. If you're working for me as my employee and you get hurt on the job, I have a requirement by law to carry workers' compensation insurance and to pay you for your lost wages, your medical expenses. If you have permanent disability, a disability payment, partial disability, whatever. That's why you have to require insurance, if not, you're personally liable. Question?
In the workers' comp, I was like the business owner. Does that come out of your pocket or like an insurance?
Okay, so if you have workers' compensation insurance, they pay it. You gotta pay the premium.
Yeah.
If you don't pay the premium and you don't carry it, you are personally liable.
Is the premium like the starter pack, like to get it started?
What the premium, the premium will depend on the type of work. So like construction, logging, commercial fishing, commercial scuba, commercial diving,
Yeah.
either scuba or hard hat, high-rise building, any area of work where you've got a lot of risk, your premium the employer pays is going to be way higher, as opposed to like me in my law office pushing papers around, right? Pretty low risk. Might cut my finger if I get a cut or something. All right. Those hurt. Page 56. 100%. 100%. Question? Aha, great question. Reckless.
Unintentional or
Okay.
strict violence?
Reckless. Reckless can be here. Reckless is actually none of these. It's because it falls under crime. These are civil. So in criminal law, you have intentional, knowing, reckless, criminally negligent. So intentional torts could be reckless. A negligence could also be reckless, but that's the criminal side. So in criminal law, you have 4 different levels. So there's slightly different things. But yeah, it's like reckless driving, right? Reckless driving is defined as a conscious disregard for a substantial risk. So if I'm going 100 miles an hour, through the campus here, or not even 50, I'm going to probably get busted for reckless driving, because I'm driving in a way that's a conscious disregard for safety. That would be a criminal thing. That would also potentially be negligence if I hit somebody, if not an intentional tort. So they're kind of separate. So reckless falls under criminal law. Yeah. Reckless could fall into any one of these, civil. Most likely negligence or intention. All right. Okay, page 56 and 57. So 100%. Here's the question, almost word for word. List 6 types of intentional torts. We're going to talk about 17 of them on this page and on the next page. There are more than 17, but that's what we'll talk about. So, battery, assault, intentional false imprisonment, infliction of emotional distress, libel, slander, anything on these next 2 pages is a good answer. So that's the one question that I'll ask for sure. And then I also want you to know just in general, like what each of these different torts are. I'm not going to make you list out every little what we call element. Don't worry about that. So these are a list of the various different types of intentional torts. Now again, most of these could also be a crime. So when I say it, you're going to say you can't do that, that's a crime. Yeah, it is. But it's also a civil tort. So let's start with letter A, battery. Classic intentional tort. A battery basically is when you, again, there are 4 elements. The intentional, that is on purpose, conscious, thinking about it with intent. Harmful or offensive, that's the number 2 element. Contact with another person, and you don't have their consent or legal justification like self-defense. Okay? So, classic example is punching somebody in the face. I walk up, punch somebody in the nose. That's a bad one. Okay? I did it on purpose. I broke their nose. That's harmful. I had contact with their face, and I didn't have their consent to punch them in the face or legal right to do so. Classic battery. Now, here's what I want you to know. I will test you on battery, I guarantee it. There are a couple different nuances to this tort I want you to understand. First of all, I have contact in all caps and highlighted on purpose. All caps like I'm shouting at you, right? And then notice I have an arrow drawn from intentional to contact. Let me explain why. Battery requires a contact, either body part, fist to face, or could be physical item. So like I hit you with my car that I'm driving. My body didn't actually contact you, but the car I'm driving contacted you. Or you're in your car, I'm in my car, and I see you and I speed up and run into you on purpose. I didn't actually touch you, I touched your car and then you were hurt. So there was still contact. In order for it to be a battery, this is the key. The contact must have been intentional. Focus on the test. I'll give you a little fact pattern. And I'm going to ask you, is this a battery or not? And I want you to focus on the contact. So Bill hit Ted in the head with a bed. That was red. While he was moving it up the stairs, and it slipped out of his hands. Bill hit Ted in the head with a bed. That slipped out of his hands. Is that a battery?
No.
No, why?
No.
Hit him in the head.
No.
Exactly, exactly. Non-intentional, exactly. So it was an unintentional contact, right? So if he dropped the bed on his head on purpose, that's intentional. So you've got to have that contact. That has to be on purpose. That's what I want you to focus on. Yeah.
For that example that you gave, would it be assault or would not be?
It wouldn't be either one of these because it wasn't intentionally done. Assault requires that you put somebody in fear intentionally. Now,
So if there's no contact, is it not battery?
correct. No contact, no battery. Now, would I still be liable for injuries? Probably under a negligence standard. And we'll talk about that next week. Because it's unintentional. Doesn't mean you're not off the hook, but it's not unintentional. And the reason why it matters, and your question's very relevant, is that intentional torts are considered to be worse than negligence. Because you intended to harm somebody. And so an intentional tort can lead to what's called a punitive damage. That is a higher amount of money to punish somebody that did that. Typically negligence, it's accidental, if you will, and you don't get punitive damages, because you didn't mean to do it, right? I didn't mean to run into you, I just wasn't paying attention. Intentional torts, I ran you over on purpose. So it's considered to be worse conduct. Yes.
If the contact was verbal, that would not be bad.
If there's no contact, there's no battery. You've got to have contact. Yeah. Now, it might be one of these other ones, but not battery. Okay. So it has to be intentional contact. Now, you can have contact that's unintentional, that's not a battery, right? All right, number 2, harmful or offensive. Now, let me focus on that for a minute, because this trips people up sometimes too. Harmful or, not and, or offensive. Let me explain the difference. Harmful contact is an injury. I hurt you. Offensive contact may be contact that does not produce a physical injury, but is offensive in nature. So even if I didn't hurt you, if the intentional contact was offensive, that's still a battery. Now, here's the question, right? True or false? A battery requires an injury.
No, it's false.
No, it's false. Correct. If it's offensive, even if it doesn't cause an injury, then it could still be a battery. Classic example of that would be somebody that touches somebody's private parts without consent. Not necessarily causing a physical injury, but it's offensive, right?
And that's still valid.
Yeah, so the person that was touched could sue for battery, yeah. Harmful or offensive, yeah.
Well, obviously, that's like their private parts, right? If they came up.
Well, yeah, if I went up to you and
Oh, you're looking, yeah.
I mean, yeah, it could be, or if I came up to you and I went, spat in your eye, right? Yuck, ooh, gross. Assuming I have no communicable disease or anything,
Still, right?
I mean, it's gross,
Yeah,
right?
it's different.
Yeah, that's offensive, yeah. Or you get the idea. Okay. Now, here's another one where people get tripped up. Yeah, question about it.
Have you ever had a case that deals with sports, like?
Thank you, yes, I was just gonna get to that. Can you hold that thought for a minute?
Yeah.
Because that deals with consent. Hold that thought for like 1 minute. Because I want to talk about this other thing before I forget. Because I have a test question on this point. Okay. Intentional contact does not mean, gesundheit, does not mean consent to cause the injury. Intent to cause the injury. Let me explain. It's still a battery even if I did not intend to injure you, but I did intend to hit you. Example. Bruiser Cruiser. What's the other one? Slug Bug? Slug Bug game, right? My kids used to play this on the way to softball. See a VW bug, right? Slug Bug, you punch your neighbor in the shoulder. My kids used to do this, all drive me crazy. Or Bruiser Cruiser was the other one. PT Cruiser, do they even exist anymore? So, I punch you in the arm. I see a Volkswagen Bug, punch you in the arm, and I break your collarbone. Didn't mean to. Oops, sorry. My bad. Is that battery? Didn't mean to hurt you. But what did I mean to do? Right. Intentional contact, once again. So it's not the intent to harm. Now clearly if I hit you and I intend to injure you, that's battery, no problem. But it doesn't necessarily have to be that way. It's the intent to have contact. Even if I didn't mean to hurt you, I'm still responsible for it because it was intentional contact. All right, now to the consent thing in sports. Okay, so without consent or justification. Justification is legal authority. So like self-defense, a police officer making an arrest, other legal uses of force. So consent is the other one. So when do you consent to being intentionally hit? Sports, right? So in court, boxing, of course, martial arts, football, basketball, all kinds of sports like that. You've got this built-in consent that's inherent to the activity, right? So if you're engaged in an activity, you are impliedly, if not expressly, consenting. So any kind of a contact sport, football, basketball, boxing, ping pong, all the contact sports, right? That was a joke. Ping pong's a contact sport. Oh yeah. That's Forrest Gump. So, Garrett Blunt. You guys remember what I'm talking about? Boise State game? After the game was over, was it before or after the game? It was after. I didn't went and punch the guy. How about James Harden? Got elbowed by, yeah. What was the guy that did it? Not a world peace, but I can't remember his former name.
Better work, Ron Artest?
Yeah, that's it. So he goes up, jams the ball, and then elbows Ron Artest went up and elbowed James Harden in the face after that. You guys remember that? This was several years ago. You can look it up on YouTube. So the big discussion at the time was, okay, was that intentional or not? I've looked at it several times. I thought it was intentional, but whatever. So yeah, is that now, so if I go up and elbow somebody, or game's over, the play's over with, I'm the defensive tackle, and I just go totally blast the quarterback. Ball's totally out of his hands, the whistle's blown, and I just pile drive into the ground. Is that within the scope of consent of football? Yeah, that's gray area, right? Where does your consent end, and when is it part of the game? And when does the heat of the moment come in, right? I don't have an answer for that, but I've often thought about researching that. Most of those cases at the pro level especially, where you had something like the old pile drive after the call, that went way beyond, those probably get settled out of court when you're here because of non-disclosure agreements. But yeah, so that's a great question. But there is a scope of implied consent. Now, third place consent applies is when somebody takes a knife and cuts you open on purpose and you pay them for it. What do we call that? When would I pay somebody to cut me open? Surgery, right? Surgery is battery. The doctor's cutting you open on purpose, causing you an injury. When they cut you, that's an injury. It's done intentionally. But the reason why it's not battery is because you agreed to it, hopefully. What if I'm going in for knee surgery? I have bad left knee. So I go in for knee surgery on my left knee, and they worked on my right knee instead. Oops.
You can sue for that.
Oh, yeah. Or they go in, I got a tumor on my kidney, and they're going to remove a kidney, and they remove the wrong kidney. Left the one with the tumor in.
So you're dead either way.
Bad news.
Yeah.
So the reason surgery is not a battery is because you consent. Flip side is if they operate on the wrong body part, it is a form of battery. Right? Depending on the doctor now, when you have knee surgery or most surgeries, before the surgery, the patient and the doctor will sign the Sharpie on the knee you're going to work on. A lot of doctors also I've seen, they have a sticker that has a big stop sign on it. And they put it on the knee that you're not going to operate on.
What happens to the patient that doesn't consent?
Okay, so if they don't give consent, and it's a non-emergency situation, then it can be malpractice. In an emergency situation, there's a form of what's called implied consent for like an ER doctor to basically do what's necessary, reasonably medically necessary to get that person out of a trauma situation. So, you know, if you're in a car crash, you're knocked unconscious, you're bleeding out.
A little bit.
Right, so there's implied consent argument there. Question?
So is that like also with the Good Samaritan law, where if you come across somebody not breathing, you administer CPR?
So that's Good Samaritan law. So,
But that saves you from a battery, right?
well, theoretically, yeah, I guess it could be. So if you cause more damage than you
Yeah,
have.
to crack ribs.
Right, yeah. But there's also going to be, that's going to fall also under justification. So, because it's or justification, so there's going to be like a legal argument that I was acting in good faith trying to help the person, and it's within the scope of that justification, yeah. All right. It's a Jerry Seinfeld episode, isn't it? About the Good Samaritan or not doing something. Okay, hidden behind. Assault. Assault basically is scaring somebody, putting them in imminent fear, intentionally putting them in fear that you're going to hit them. So it's the intentional act of putting somebody in imminent fear of an impending battery. And the person's actually aware of it and is afraid. So I pull out my baseball bat, I start chasing after you, I'm going to hit you, and you run away because you're scared. That's assault. Now, I can't catch up with you because I'm not real fast, I kind of hobble along. So I never catch up with you. If I hit you, it's a battery. If I do both, I swing at you and I miss, that's an assault, and then I swing and I hit, that's an assault and battery, right? You heard that, assault and battery. So what I want you to know about an assault, you have to show imminent. This word imminent, that means right now. Not a couple hours from now, not tomorrow, but right now. Imminent. So let's say you're asleep on the couch, and I swing my golf club at you on purpose to scare you, but you're asleep, you don't wake up. And somebody videotapes me doing it, and they put it up on YouTube, and next week you see it, and you go, ooh, that's not cool, and you're scared. Is that assault?
No,
No, why?
because you didn't.
I didn't hit you. Assault doesn't require contact.
Oh, but.
You're right, it wasn't right then. It wasn't imminent right now. Now, it might be something else, it might be one of these other ones. And while I'm on that point, just because it's not one of them doesn't mean it's not another tort. Also, it could be more than one, right? Question.
So if I threaten to slap you, that's assault?
If it's imminent and it's in such a way that you do it on purpose,
Yeah.
with the intent to cause imminent fear.
So if I just made a threat and you were scared, it had to be
It
assault?
could be assault, yeah.
Okay.
Now, again, these are also potentially crimes, so that could also be a crime of either menacing or harassment, or they go by different names. Yeah. Of course, the classic one there is somebody pulls a gun on someone. Doesn't actually shoot them, that would be battery. They scare them, right?
So what if I threat you, like, not right now, like, let's say.
In the future?
Yeah, if
Okay.
you don't do this, I will
This
do that to
requires,
you tomorrow.
this requires imminent fear. Now, that would probably fall under this one.
Outrageous conduct?
Right.
Infliction of.
Intentional infliction of emotional distress. That doesn't require imminent. So again, the idea, these are not necessarily exclusive. You can have more than one, or just because it's not one doesn't mean it's not another one. All right. So that one's pretty straightforward. Put somebody in fear of imminent battery. Letter C, false imprisonment. Okay, so these are the elements. Again, I'm not going to make you write out all the elements, okay? So you don't need to memorize every single element. I want you basically to have this level of knowledge. I'll give you a fact pattern, something like, Bill locks Ted in the closet overnight and won't let him out. What tort might that be? And then you got to pick from, what tort it would be. So false imprisonment. So if you have that level of knowledge, that's kind of what I'm looking for. And again, it may be more than one of them. So read the answers. So I may say, okay, this could be false imprisonment and intentional infliction of emotional distress. Could be both. Doesn't have to just be one.
The answers are in the problem. You just have to read, like.
On a multiple choice question, they
Yeah,
are.
every
Now,
time.
true and false, but yeah, and I like your point is well taken.
Like when you read, like you can read about something, then the next question will come up with the same thing that you just read.
That's right. And that's good test-taking technique. So, and especially like in multiple choice, if you know it's wrong, cross it out.
Yeah, and go back again.
Increases your percentages. All right, so false imprisonment. So this is intentional, again, on purpose, confinement of somebody, and I want you to write it here, or moving them, movement, not necessarily confining. So in other words, I grab somebody by the arm and I'm dragging them down the street. I didn't actually confine them, but I moved them against their will. For some appreciable amount of time, not just, oops, I'll lock the door and whatever, and open it right back up. Without consent or legal authority, called privilege, like making an arrest. and the person is aware that they're confined. So it's not like they were sleeping and I locked the door or something. Okay? Again, it has to be intentional. You may know what this would be criminally. This could also be a crime. If I can find kidnapping, exactly, and or a menacing would be a lower level. So, let me give you a scenario. You tell me what you think. Say I'm a bus driver, school bus driver, and I drive kindergarten through 6th grade kids. And so I'm driving my route, and at the end of the day, little Johnny's asleep in the back seat of the bus. Little Johnny's like 1st grade. So I go, after I'm done, put the bus in the bus barn, lock the bus up, and I go home. Little Johnny wakes up, starts screaming, stuck in the bus. Of course, then parents are like, where's little Johnny at? And it's bad news, right? Is that this?
No.
Why? You're right.
Because
Confinement.
he wasn't trying to take it.
Wasn't trying to,
He wasn't trying.
meaning
He didn't know.
didn't have intent, exactly. No intent, was not done intentionally. Now, does that mean that the bus driver's off the hook? Not
No.
necessarily, it could be negligent, right?
Yeah.
But it's not gonna be an intentional tort, right? Unless it was done intentionally, purposely, trying to, right? Okay, how about this one? This actual case I had here several years ago. Grocery store. Big brand name, you guys all know it, I told you, but I won't. So grocery store, security guard, bust somebody for shoplifting. Guy stole like a 6-pack of Dr. Pepper or something, right? Not a major shoplift, but it's still theft 3, lower level crime. So they bust the guy shoplifting, they take him back to the back of the store to the security office. And in the security office, they've got a 2x12 board that's on top of cinder blocks. And on the board, they have lag bolts with handcuffs bolted to the board. They set the guy down, and they handcuff him to the board, and they leave him there for 6 hours without calling the police. Private security guard. Paul Blart, right? He got off his Segway and arrested somebody. So, police show up after 6 hours. They show up, like an hour later, because it's not a major crime, and they take the guy into custody. They charge him with theft 3. Guy's convicted. Turns around and sues the security guard in the store.
Because it wasn't his job.
It was his job to arrest, but
He has no authority to hold him.
No, he does.
for a while he does, but 6 hours?
You didn't immediately turn him over to a police officer.
Exactly.
6 hours?
Yeah, he didn't call the police for 6 hours. Why didn't he call the police? To punish him, right? So, yeah, so the guy actually sued, and they settled the case, but had it gone to court, I'm sure it would have won. Seriously. I was actually the DA that convicted the guy, and I got called as a witness in that case. Yeah.
Would you sue the security guard and the store
Yeah.
in that case?
Yeah, it's called respondeat superior, which is the employer is responsible for the actions of the employee, but I also sue the employee personally, yeah. Because, this gets way detailed, but an argument sometimes can be made that the employer did not consent to an intentional tort. It's not within the course and scope of the employer. And sometimes an employer can get out of liability, whereas the employee would still be liable. But in court, and typically in that case, the court would say that's within the course and scope, hold the employer liable. Yeah.
I also take that case specifically, it's this private security guy, he went beyond what the actual.
Oh, absolutely,
The
way
statutes
beyond the
say,
privilege,
yeah.
yeah. You gotta call law enforcement
Yeah,
right
that's-
away. Now,
that's
had he
my
called
question.
law enforcement, it took him 6 hours to get there, that might have been a different story, All right, next one, letter D. Infliction of emotional distress. So, this requires, again, intentional, but this could also be reckless. So you asked about reckless. Reckless could fall here too, reckless conduct. So this is where somebody engages in intentional conduct that is outrageous in nature. Outrageous basically is something that the reasonable person would just be shocked by. that causes severe emotional distress in someone and is intended to do so. And the person who is the victim is not overreacting, so to speak, is not being hypersensitive. In other words, the average reasonable person would also react in that same way. So let me use some examples and tell me what you think. All right, so we got Super Bowl coming up. So we have Patriot fans and Ram fans. And so I'm in Rotary Club. This happens all the time, like a Civil War, Ducks and Beavers and whatnot. So we have Duck fans, we have Beaver fans, or we have Patriot fans, we have Rams fans, whatever. So they're dishing each other, right? Oh, your team's horrible, and they shouldn't even be there, and blah, blah, blah. And the other person's saying your team's awful, and I mean, it gets pretty heated. So let's say it gets so heated, somebody's dishing on somebody's team, that the person just gets so upset, they have to go to the doctor, and they're forever scarred for life. Is that this? It's intentional. You're picking on the other person's team, and them by implication, because they're a fan. Why? I don't think it is either, but why?
Hypersensitive.
You could argue that they're overreacting, that the average reasonable person would not have been that distraught. You could also make an argument that that conduct itself is sort of within the realm of sports fandom or something, I don't know. So, okay. How about this one? You're my next door neighbor. And I don't like you, for whatever reason. And you have a little baby girl. Well, she's not baby, she was about 11, 12 months old. Okay, a toddler, a little girl. Just starting to walk, right? So I call you on the phone one evening, and I say, I just saw your little girl. She was walking out in the street by herself, and she just got ran over by the UPS driver, and she's underneath the truck, and she's dead. And you, like, have a heart attack right there in the spot. I'm lying. I did that intentionally to make you have severe emotional distress. Is that different? Is that outrageous? Oh, yeah. Average person have severe emotional distress over that? Like, yeah. See the difference? Don't do that. That's just flat out rude. Okay. Defamation. Defamation, libel and slander. I have these both highlighted. I want you to know the difference between the two. So first of all, defamation in general. Defamation is the intentional tort where somebody either verbally or says something or prints something false, publishes something false about another person that's defamatory, it's negative, and it's not true. And as a result, that person's reputation is damaged. So that's the basic overlying tort of defamation. Now this tort goes back a long time. This goes back to Old English common law, way before the United States ever existed. Most of these do. Most of these are based on English common law. But this one especially, under English common law, had two different types. The first was libel. Libel was written defamation. So a newspaper, a pamphlet, a poster board. Go back to the days before we had the internet and all the stuff we have nowadays. You had basically verbal, people talk to each other, or you printed something, maybe it was only handwritten or Gutenberg press or whatever, but we didn't have websites and all that. You had verbal and you had written. And so the difference was libel, written, slander, verbal. So libel was considered to be worse than slander because it was in the printed format. In a semi-permanent nature as it's printed. It's put out there to the public. You don't know who's going to read it, and it can be read over and over again. Slander, verbal, considered not as bad. Yeah, question?
Is slander the same thing as slang? Like the slang verbiage?
Not necessarily. I suppose there's probably, like the word slang and slander come from some same word derivative somewhere along the line, but I mean, slang could be slander, I suppose.
Yeah, that's what I mean.
Yeah. If it was false. Yeah. So, long story short, I want you to know the difference between libel and slander. Libel, printed, slander, verbal. Now, fast forward to today, where we've got the internet, cable TV, and talk radio, and satellite TV, and posters, and holograms, and blogs, and this and that's, and YouTubies, and their tubies, and Vimeos, and Vimeos, and Julio, and all that different stuff, right? You have so many ways you can libel somebody, it's like you run out of time. So nowadays, how do you tell the difference, okay? So like talk radio, or radio in general, that's a verbal media, but it's published on the mass, the airwaves. So it's not really like old-fashioned slander where I got up in front of a bunch of people and said something, and my words just kind of went away, because it's out there on the radio, it's rebroadcast. So is that more like slander, or is it more like libel? Even though it's verbal means of communication. Well, it's really more like libel, because it's public, broadcast publicly. You don't know who's hearing it. It could be rebroadcast. So pretty much nowadays, any kind of public media, radio, television, internet, statute, anything physical form, is going to be considered libel. Slander is still good old face-to-face talking bad about somebody, right? Or perhaps over the telephone. I call somebody on the phone and say something that's not published or out there in the public. It's a private phone call. All right, so I want you to know that it's written or some media, oral, purely verbal. Now, just so you know why it matters, for libel, it's considered worse than slander. And in that case, you don't have to prove, if it's libel, that you had what we call special damages. That's just a fancy way of saying something bad actually occurred as a result. You lost your job, you lost a client, or whatever. Slander, you had to prove that something bad happened as a result of the false verbal statement. You lost a client, you lost a contract, you got fired, whatever. You had to prove something bad actually occurred, right? That's the difference. Libel, your reputation damage alone is considered damage done. All right, now there's a bunch of other nuances, but let's focus on the ones I really want you to know. Okay, so first of all, libel versus slander. Second, the word publication. Publication, obviously, I put it in the news or whatever, magazine, but it could be more than that. What I mean by that is the statement is made to someone other than the person you're talking about. So if I walk up to you and I say, you're a heroin dealer that sells child porn and you're from Mars, and I say it to your face and nobody else hears it, that's neither of these. Now, it might be something else, but it's not defamation because I didn't say it to a third party. I didn't put it in the public realm. So in order for it to be libel or slander, it has to be said to somebody else. Does that make sense? That's what we mean by publication, someone other than the person you're defaming, basically. Next one, the statement must be false. Not true. False. Provably false. Now, what do I mean by that? Provably false. Well, something's either true or false, right? Right? Okay, so what if I say this? Diet Coke's better than Diet Pepsi. Is that true or false?
You said what?
Diet Coke's better than Diet Pepsi. Is that true or false?
That's definitely true. Pepsi.
I would say so,
Yeah, I'd rather drink.
but is that true or false? So now I get sued by Pepsi Company because I'm defaming their product.
Well, shit, if it's nasty, it's nasty.
See what I'm saying? Is it provably true or false? How do you prove something's true or false?
You test it.
That's one way. What are we talking about?
Facts.
Facts. Factual, false, factually true. Provably. So if I say Diet Pepsi or Diet Coke's better than Diet Pepsi or vice versa or Mountain Dew or whatever, because I like it better, that's my personal opinion. It's not a factual statement, it's a subjective, non-factual matter of opinion.
Because how do you feel?
That's exactly, that's how I feel. In fact, I guess you could say it another way, it's true to me.
Okay.
Provably false. Diet Coke is better than Diet Pepsi because Diet Pepsi has nuclear waste in it. Now, I've made a factual statement that can be proven one way or the other through testing, like he said. Right? See the difference? So it requires it to be false. Now, I get calls on this from clients all the time. Somebody posted on Facebook about me that my restaurant is the worst they've ever been to. I want to sue them for defamation. So first question I ask them is, well, is it? Is it the worst? Well, yeah, it is. No, but again, how do you prove that, right? So one person may think it's the worst, and that's, you know, all the reviews on TripAdvisor and Yelp and all that stuff. That's subjective. Now, if somebody put on Yelp or whatever, it's the worst restaurant ever because they flunked every single health department inspection they've ever had. That's different. Now we can go pull the inspections and find out, right? You see the difference? So that's where, you know, we actually see a lot of this now with all these reviews and, you know, TripAdvisor and Amazon review and all that. Yeah,
Now, we say provable, I mean, like,
provable, provably false.
provably false, right? I just want to say, like, I found a Band-Aid in my mashed potatoes, and they have a picture of mashed potatoes with a Band-Aid. I mean,
So it's true.
well, was that from the building?
Oh, well, yeah.
I mean, that's what I mean, is like, how provable does it have to be? Like, when you said, like.
Okay, so that's a great question. So the answer to that question is the person who's being defamed. So if you put a thing in there, the person who's being defamed has to prove it's false. So they have to prove that they didn't put the Band-Aid in there, basically. Or if you're calling me, you know, a heroin dealer, I have to prove I'm not a heroin dealer. The burden's on me to prove it's false, which is hard to do. You're proving a negative. It's hard to do. That's why these are very, very difficult cases. Unless it's very, absolutely factually false, easily proven, it's kind of a waste of time.
Okay, I have a question.
Yeah.
So, like you said, the man with the restaurant,
Mm-hmm.
say that people order this type of meal just because everybody tries it, right?
Right.
So the sales are out of the roof for that particular item. But on the factual side, it's nasty as hell.
Well, and so again, it's going to depend on, some people may like it, some people may not.
Mm-hmm.
So again,
Well,
that's
can you-
factual opinion.
But could he like sue just because people buy that same dish
No,
more than the other?
no, because it's still going to come back to, it's a matter of personal opinion.
Yeah.
Now, if somebody made a statement that the food is horrible because it has
Something in it.
rat parts or something, and provably false, you know, you can again, back to testing, like I said before. If you can test it, it's factual, yeah.
So what about like, what was it, Donald Trump when he posted, false claims?
Okay, so that kind of goes to number 5 here. So let's say something is provably false. But what you're doing is you're talking about a public figure. So now we have the First Amendment that comes into play, right? So the First Amendment, free speech, freedom of the press, provides protection, theoretically, against libel and slander to a degree. And so in order to win, even if it's provably false, if the person you're defaming is a public figure, there's another element. To get above the First Amendment, you have to prove that the statement was made with what's called malice. And that's basically, you knew it was false, you had evidence to the contrary, and you published it anyway with the intent to damage something. And so that's why, you know, like the National Enquirer and stuff, you go, eh, read the front page like, that can't be right. They don't have actual malice. So the First Amendment comes into place. The First Amendment didn't exist in common law. So we have this kind of a conflict between defamation and freedom of speech, freedom of the press. Yeah. And courts, where that line is, very difficult. All right. So, libel versus slander, know the difference. Printed,
Verbal.
verbal. It's got to be false, provably false, not just an opinion. If you know kind of those, you're good enough. Okay. invasion of privacy. So this again is a tort, intentional, do it on purpose. This goes by several different names and depends on where you're at. This is also an area of tort law that's evolving with technology. So this has different types. These are actually different torts in and of themselves. So one type of invasion of privacy would be intrusion on somebody's personal solitude. So the example I gave here is like if I set up a spy cam in somebody's hotel room and I was broadcasting it on the internet, something like that, that would be that tort. Isn't that a movie with Jim Carrey? Truman Show? Falling around.
I don't even remember.
You guys know Jim Carrey. Dumb and Dumber movie. I had a term once where nobody had ever heard of the Dumb and Dumber movie. One of my favorite all-time movies. It's Dumb and Dumber. Okay. Number 2, public disclosure of private facts. So this is where somebody has information about somebody that they obtained in a manner that is privileged, so like doctor-patient, lawyer-client, pastor or clergy or whatever, their psychologist or psychiatrist or whatever, and they disclose that information intentionally. That can be this tort. All right, now let's compare this with defamation. So let's say I'm your therapist or whatever, and you tell me that you are a heroin dealer, that you're a child porn dealer, and all these are super bad things, right? And then I go on some talk show, I say, oh, guess what my famous client told me? They're a heroin dealer and a child pornographer and all these things. It's true. Is that defamation? When I go on talk show and say that? Is it defamation? What does defamation require? False. So you told me that you're a heroin dealer and a child pornographer, and I went and disclosed that. It's not defamation because it's true. But that would be this tort here. I disclosed information that was given to me in confidence. So again, just because it's not one, it's the other.
Well, then, what would defamatory apply?
It's gotta be false. So if
Got
I
it,
go,
okay.
if I publish something that says you're a child pornographer and you really are, yeah, it's bad.
And it may be inflammatory as well.
Oh, absolutely.
Well, yeah, okay, so, but as long as it qualifies false, it automatically covers inflammatory.
Well, I guess, maybe not. So I guess, if I publish something false about someone that wasn't bad, it's like maybe it's like, I don't know, you're the best cook in the world or something, it's not true. But it's not really bad. You have to show it's defamatory, meaning it tends to diminish your reputation. Does that make sense?
Yeah, well, okay, where I was going with that, like, if one on the public record said, my client is, or versus he was, because I went through your training, your therapy, and now I'm no longer doing that anymore.
Oh yeah, just the thought, just the very implication that your therapy itself could be,
That's,
yeah, so I see where you're going.
okay.
So yeah, that theoretically could be. Of course, then we also have federal law that comes into play here too,
Right.
like HIPAA and that kind of stuff, yeah. All right. False flag. So this is basically putting somebody's name, likeness, or actions in a false way. This could also be defamation. So like if I Photoshop, I take a video and edit it, make it look like you did something you didn't, or I Photoshop, those kind of things. And then finally, appropriation of name without permission. This is where I use somebody's name for a commercial purpose without their consent, like in an advertisement. So like I Photoshop, I use Brad Pitt holding up my product or whatever, if he didn't give me permission, then he could sue me for that. Now, again, these are changing fairly rapidly because of technology. So spy cams, right? Everybody's got a phone nowadays, and I guess iPhone, we just found out that people can get in on your FaceTime conversation without permission. There's another huge area. It's just starting, but probably within the next few years, we're going to see like this intrusion of personal solitude just explode. What kind of technology?
Drones.
Drones. Yeah. it's probably already, I mean, it's already happening. So this is kind of interesting, because this is where technology and law kind of clash with each other. Okay, I'm gonna stop there, so remind me next week. We'll pick up with malicious prosecution, and then we're gonna talk about evidence. So make sure you sign in. If you haven't signed in, here's the sign-in sheet.